Hello, everyone. This is Tom Fox back for another episode. And for those watching on video, you will see Jonathan Wilson, one of my most frequent guests over the past several months, for what may be his last appearance for a while, which he will explain why. But first of all, welcome back, Jonathan.
Thank you, Tom. Glad to be here.
Jonathan is wild and woolly and as crazy as things have been since mid-December. I thought they took an equally crazy turn a couple of weeks ago. Can you tell us what happened?
Absolutely. Yeah, this was an outcome that I don't know that anyone had on their bingo card. On March the 2nd, when most of us were watching the Oscars, the Treasury Secretary cut a press release saying that he believed it would not be in the public interest to have a database of beneficial ownership reporting, and therefore he was planning to issue a new regulation that would effectively exempt all domestic reporting companies from ever having to file their BOI reports. And then a few days later, around March 21, they actually released a copy of that regulation, which was published in the Federal Register on March the 26th. And that new regulation, what they're calling the interim final rule, it does exactly that. It exempts from having to report all domestic reporting companies. The only companies who are left having to report are the foreign reporting companies. And it's important to remember what the definitions of those two things are. A domestic reporting company is any entity that has been formed in any one of the 50 states. So 50 state corporations or LLCs. Even if 100% of the shareholders are non-U.S. citizens, if it's a U.S. corporation, it's a domestic reporting company, does not need to file. The only parties who still need to file are foreign reporting companies, which are entities formed outside the United States that have registered to do business in the U.S. So if you are a German GmbH or an Italian SA de CV, and you are registered to do business in the U.S. by filing a document with the state Secretary of State, that entity does need to file its BOI report. Now, as everyone remembers, we believe that there were about 33 million domestic reporting companies. Those are the ones who no longer need to file. And FinCEN had estimated that there were less than 100,000 foreign reporting companies. Those are the ones left filing. Now, the obvious question is, if you're a foreign reporting company, why not just drop down a wholly owned subsidiary, a Delaware corporation or an LLC under one of the other states, and thereby be relieved of the duty to file the BOI report? I would expect that most of our foreign friends would do exactly that. So the practical effect of the interim final rule is to basically relieve most all of the world of any duty to file BOI reports under the Corporate Transparency Act.
Jonathan, I think we both agree that we have lost a huge resource with this tool. Can you maybe outline some of the things we won't have available to us by this evisceration of the CTA?
Sure. The model that Congress had in mind was that 33 million companies would file BOI reports, and that would create a resource that could be used in several different ways. Federal law enforcement could use it to know who the beneficial owners of any company would be. So you could literally look it up if you were the right level of security inside the federal government and see that Acme Corporation is owned by Larry Moe and Curley. State law enforcement was supposed to have a similar ability. Again, there were safeguards for security and confidentiality, but state law enforcement could also look up to see who were the beneficial owners of a particular LLC. Then financial institutions like banks and others that have anti-money laundering obligations, in coordination with their anti-money laundering obligations, they would be able to look up the beneficial ownership of their customers with their customers' consent and compare it to the documents that the customers were providing, presumably to make sure that everything added up. Those were the three primary use cases of the beneficial ownership database. Now, since no domestic reporting companies are filing and precious few foreign companies will be filing, neither one of those three classes of users will be able to use that data in that way.
The information that we would have had available to us was part of the AML Act of 2020, which was the first update to the Patriot Act, since the Patriot Act was initially passed back in the wake of 9/11. And this was a major attempt by the U.S. government to bring its anti-money laundering tools not into the 21st century, but certainly into the 2020s. It would seem that we have lost a major tool in the fight against money laundering. And I realize money laundering is not directly in your area of practice, but are you hearing or seeing anything along those lines?
No, you're right. I don't primarily give advice to banks. I'm more of a corporate lawyer in in my private practice. But yes, one of the chief purposes for Congress passing this law was to respond to criticism that the U.S. had from the FATF that the U.S. system was non-transparent and therefore it lagged most industrialized countries when it came to corporate transparency. After Congress passed the CTA, FATF basically moved the U.S. back into a compliant status, and presumably now that FATF criticism is going to come back around again, since effectively the CTA is not being implemented.
The other area is similar to the executive order suspending enforcement and investigations under the Foreign Corrupt Practices Act. One response is you may have suspended investigation and enforcement, but the law is still the law. Does that hold true for the CTA? And if so, what does that mean?
It's definitely true that the law is still the law. Congress passed this law, and it is still on the books. It is being enforced through the interim final rule in a way that effectively does not enforce it. Now, the Treasury Department can change its regulations at any time it wants. Secretary Bisson could wake up next week and say, I think I got it wrong. I want to change my mind. Not very likely, but it could happen. Some other presidential administration, some other Treasury Secretary in the future could change the regulations with relatively little notice and effectively put us back on a time track for everyone to file again. For people who bought one of my books years ago, I say, don't throw it out just yet. You might put it in the back of the shelf, but maybe dust it off around 2028 because all these rules for determining beneficial ownership might become relevant again.
I have read the Secretary's directive, and frankly, it occurs to me that it is an antithetical reading to the plain language of the statute. However, I'm not in a position to challenge that ruling. But if there was a party that had standing, could that interpretation by the Secretary be legally challenged?
I think if there was a party with standing, that would be a very interesting challenge to hear. I think there's a very good argument to be made, but especially when you read the sense of Congress as described in the statute, where they describe the need to have this database of beneficial ownership. And clearly Congress anticipated that more than 30 million companies would be filing. They say so much in the sense of Congress background of the statute. And yet clearly the interpretation relieves all 30 million of those companies of any duty to file. So that's an antithetical implementation of the statute. But as you say, who has standing? Those of us who are in the business of filing reports, we don't have standing. Businesses that no longer have to file, they aren't harmed by being relieved of the duty to file, so they don't have standing. Who does have standing? Some of the Republicans will recall a few years back when they didn't like the way the Biden administration was enforcing border laws, that they tried to sue on the theory that the executive branch wasn't adequately enforcing the border laws. To my memory, most of those cases were resolved against standing for various reasons, and I'm not so much of a constitutional scholar to understand why that is. So who might possibly have standing to sue on these regulations? I don't know. The closest argument I can come up with is that perhaps a state attorney general might make the argument that they had anticipated having access to the BOI database for state law enforcement purposes. That was part of the purpose of the statute. But with this interpretation of the statute, that database has gone away, and therefore state law enforcement has been deprived of this benefit it would have gotten under the statute had it been enforced as Congress intended. I'm not enough of a constitutional scholar to handicap how that case might turn out.
And there are still actually several lawsuits going on over the constitutionality of the act. Do you feel like those cases are now mooted, or will they continue to percolate upwards?
That's a great question. I kind of think they might be mooted, although mootness is another constitutional concept that I have to confess I'm not an expert on. But you're right. We're looking at the Yellen case that's now in front of the 11th Circuit, and then the Texas case and I think the Smith case are both in front of the 5th Circuit. Both circuit courts have asked for supplemental briefing from the parties based on the interim final rule. But both cases, all three cases, I think, were facial challenges to the constitutionality of the statute brought by U.S. plaintiffs who would have had to file, who no longer need to file. So I don't see how that doesn't become. Now, for what it's worth, the DOJ in its briefings has continued to assert the constitutionality of the statute as written and as applied facially. So the government has not given up on its constitutional arguments for the statute, but it's hard to see how these cases aren't moot now that there's no risk of the statute ever being enforced against any of the plaintiffs to any of those cases.
Is there anything left for us to discuss at this point, Jonathan?
Sadly, Tom, I think our days are numbered on this particular topic. I'm going to have to find some new topic perhaps that we can talk about. I do have a couple of ideas in the back of my mind, but I think our days of talking about the Corporate Transparency Act are going to be over for the foreseeable future until the executive branch changes its point of view as to how it wants to implement the CTA.
Jonathan, I wanted to thank you again for this series literally since December, although I know we talked before December, but it has been one rocking ride. You've been on top of everything. I follow you on LinkedIn and you post, you comment, you repost, you talk about other people who post. So it's been a great way for me to keep really on top of all of this issue. And I know we will continue a conversation down the road.
I appreciate it. Thank you, Tom.